Hello everybody and welcome to Legal Studies Unit 3, Area of Study 1, the Criminal Justice System Part 5. The focus of today's video will be dot points 9 and 10, the responsibilities of key personnel in a criminal trial, including the judge, jury, parties and legal practitioners, and the purposes of sanctions, rehabilitation, punishment, deterrence, denunciation and protection. Before I begin looking at the responsibilities of the judge, I do want to note that I have included 2 responsibilities for each of the key personnel, and whilst there are many more, I recommend learning 2 in depth and then knowing briefly about some others. So the first responsibility of the judge is to determine the admissibility of evidence. The judge determines what evidence is permitted and what evidence is excluded from trial. The judge makes sure that the rules of evidence and procedure are being followed. The judge, however, is not responsible for finding evidence on behalf of the parties. The second responsibility of the judge is to hand down a sentence. The judge is required to follow the guidelines stipulated in the Sentencing Act 1991 to determine a sentence that should be imposed. The judge cannot hand down a sentence that does not comply with the Sentencing Act 1991. Responsibilities of the jury. The first responsibility of the jury is to listen to and remember evidence. The jury listens to all the evidence presented by both parties. The jury attempts to fully understand the evidence given during the trial. The jury is encouraged to take notes during the trial. The jury, however, cannot conduct their own investigations. The second responsibility of the jury is to deliver a verdict. The jury makes a unanimous decision on questions of fact. The jury considers any doubts they may have. The jury cannot make deliberations public and cannot disclose the reason for their decision. Responsibilities of the parties. The prosecution and the accused are the 2 parties to a criminal case. The victim is not a party. This is important to remember, as it is a common mistake that is made by students. The first responsibility of the parties is to give an opening address. The prosecution gives the first opening address, which outlines their case to the jury. The accused legal practitioner must then address the jury by responding to the prosecution's opening address. If the accused does not have a legal practitioner, they will be required to do this themselves. The second responsibility of the parties is to assist the judge in jury matters. The parties can assist in impanelling the jury by challenging jurors. Parties can request that the judge directs the jury on an issue during the trial. Parties cannot challenge an unlimited amount of jurors without a reason. Responsibilities of legal practitioners. The first responsibility of legal practitioners is to be prepared. Legal practitioners must be prepared to give an opening and closing address. Legal practitioners must be well versed in the documents that are admitted into evidence. The second responsibility of legal practitioners is to comply with their duty to the court. Legal practitioners have a duty to the law and to the court above their duty to their client. Legal practitioners must act ethically and in accordance to the law, even if this means going against the instructions of their client. Legal practitioners cannot mislead the court or twist the facts in any way in order to assist their case. The purposes of sanctions. Punishment. To punish the offender to an extent and in a manner which is just in all of the circumstances. It allows victims or their families to seek retribution without needing to take the law into their own hands. The offender should be punished to an extent and in such a way that is just in all circumstances. Deterrence. To deter the offender or other persons from committing offences of the same or similar character. Aims to stop the offender and others in society from committing the same offences. General deterrence aims to stop the offender from committing the same offence again. Specific deterrence, on the other hand, aims to stop others in the community from committing the offence. Rehabilitation, to establish conditions within which it is considered by the court that the rehabilitation of the offender may be facilitated. It is in society's best interest to try to help offenders change their behaviour so they do not reoffend. Rehabilitation includes addressing the underlying reasons for the offender committing the offence. Denunciation, to manifest the denunciation by the court of the types of conduct in which the offender engaged. Denunciation shows the disapproval of the court and community. It is used as a way of publicly criticising the actions and behaviour of the offender. Protection, to protect the community from the offender. The Sentencing Act allows the DPP to request an indefinite prison sentence for offenders who are seen as a danger to the community. That concludes today's video. I hope that your knowledge of dot points 9 and 10 from Unit 3, Area of Study 1 have been consolidated. If you do have any questions, feel free to email me or leave them in the comments below. Thank you.